The court afforded the parties an evidentiary hearing on the jurisdictional issues and also heard arguments on Cohen's motion to dismiss and, alternatively, for summary judgment. Due process requires only that in order to subject a defendant to a judgment in personam, if he be not present within the territory of the forum, he have certain minimum contacts with it such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. International Shoe Company versus State of Washington, 326 U.S. 310, 316, 66, Supreme Court, 154, 158. The United States Supreme Court reaffirmed the minimum contacts standard. The concept of minimum contacts, in turn, can be seen to perform two related but distinguishable functions. It protects the defendant against the burden of litigating in a distant or inconvenient forum, and it acts to ensure that the states, through their courts, do not reach out beyond the limits imposed on them by their status of co-equal sovereign in a federal system. Before a court can exercise in personam jurisdiction, it must be convinced that the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed into court there. The relevant portion of the Pennsylvania long arm statute provides as follows. B. Exercise of full constitutional power over non-residents. In addition to the provisions of subsection A, the jurisdiction of the tribunals of this Commonwealth shall extend to all persons who are not within the scope of section 5301 relating to persons to the fullest extent allowed under the Constitution of the United States and may be based on the most minimum contact with this Commonwealth allowed under the Constitution of the United States. Section 5322A of the long arm statute also sets forth particular circumstances which may give rise to in personam jurisdiction. A tribunal of this Commonwealth may exercise personal jurisdiction over a person or the personal representative of a deceased individual who would be subject to jurisdiction under this subsection if not deceased, who acts directly or by an agent as to a cause of action or other matter arising from such person. Transacting any business in this Commonwealth, without excluding other acts which may constitute transacting business in this Commonwealth, any of the following shall constitute transacting business in this Commonwealth for the purpose of this paragraph. The doing by any person in this Commonwealth of a series of similar acts for the purposes of thereby realizing pecuniary benefits or otherwise accomplishing an act or object. The thing or a single act in this Commonwealth for the purpose of thereby realizing pecuniary benefit or otherwise accomplishing an object with the intention of initiating a series of such acts. Contracting to supply services or things in this Commonwealth. Causing harm or tortious injury by an act or omission in this Commonwealth. Causing harm or tortious injury in this Commonwealth by an act or omission outside this Commonwealth. While the Pennsylvania statute enumerates certain circumstances under which the exercise of in personam jurisdiction can be expected, this court must, in the final analysis, decide whether there are minimum contacts which satisfy the constitutional requirement of due process. It is settled that a plaintiff bears the burden of alleging facts sufficient to persuade the court that in personam jurisdiction exists, and once jurisdiction is challenged, plaintiff must prove by a preponderance of the evidence facts establishing jurisdiction. As stated in McNutt versus General Motors Acceptance Corp., 298 U.S. 178, 189, 56 Supreme Court 780, 785, plaintiff must carry throughout the litigation the burden of showing that he is properly in court. The authority which the statute vests in the court to enforce the limitations of its jurisdiction precludes the idea that jurisdiction may be maintained by mere averment. or that the party asserting jurisdiction may be relieved of his burden by any formal procedure. If his allegations of jurisdictional facts are challenged by his adversary in any appropriate manner, he must support them by competent proof. And where they are not so challenged, the court may still insist that the jurisdictional facts be established or the case be dismissed. And for that purpose, the court may demand that the party alleging jurisdiction justify his allegations by a preponderance of evidence. The law favors resolution of disputes on the merits. Consequently, the court must read the pleadings in the light most favorable to plaintiff. Plaintiffs allege that Cohen induced them to send a partial deposit for the concert performance, a money order for $3,797.55, payable to him for the benefit of Simone, when Cohen knew that Simone had no intention of performing in Philadelphia. Further, plaintiffs claim that Cohen negotiated the details of the performance contract as Simone's agent and personally guaranteed that if the plaintiffs sent the deposit, Simone would appear at the Civic Center. However, neither plaintiff's complaint nor the evidentiary affidavits reveal which party initiated communications regarding the Simone concert or the place of any negotiations. The court is persuaded nonetheless by a preponderance of the evidence that the plaintiffs have alleged that a contract was contemplated to be performed in Pennsylvania within the meaning of 42 Pennsylvania Reports, Section 5322A2, Supplement 1980. Such an undertaking would give the court in personam jurisdiction if the constitutional requirements are also met. The rule governing dismissal for want of jurisdiction in cases brought in the federal court is that unless the law gives a different rule, the sum claimed by the plaintiff controls. If the claim is apparently made in good faith, it must appear to be a legal certainty that the claim is really for less than the jurisdictional amount to justify dismissal.
That was pretty hard.